In a major victory for Governor Babajide Sanwo-Olu, the Lagos State Governorship Election Petitions Tribunal has ruled to uphold the outcome of the governorship election in which he was declared the winner. The three-member panel dismissed the petition filed by the People's Democratic Party candidate Olajide Adediran challenging Sanwo-Olu's election. It affirmed that Sanwo-Olu and his deputy Obafemi Hamzat were validly nominated by their party, the All Progressives Congress. The tribunal also rejected claims that Sanwo-Olu presented a forged certificate. The Lagos PDP candidate has rejected the judgment, arguing that the tribunal's decision does not reflect the provisions of the Constitution and the Electoral Act on issues bordering on the qualification of a candidate in an election. Joining us now on this morning show as we review the judgment of the Lagos State Governorship election petitions is Liborous Oshoma, a lawyer. Good morning, Liborous. Good to see you again. Well,
good morning,
very quickly, you had the introduction. In fact, the tribunal went for that to even dismiss Olajide Adediran Jandor of the PDP as a busybody, who had no business inquiring into APC affairs. What do you think?
Because a lot of people have asked me these questions even before now, citing Degi Eremiyo's case, and that case was actually the PDP that took the APC deputy governorship candidate to court, and that what has changed. If the 2010 Electoral Act, Section 35 of that act empowers anybody at all. The provision specifically provides that anybody who, permit me to read. It says that any person who has reasonable ground to believe that any information given by a candidate in the affidavit or any document submitted by that candidate is false may file a suit at the Federal High Court of a state of FCT against such a person seeking a declaration that the information contained in the affidavit is false. So what usually happens the moment primaries are conducted and the informations are supplied, and these informations are usually on oath, the law then, the Electoral Act, Section 35, permits anybody, just anybody. But with the new amendment to the Electoral Act that we are all praising, it limited who could go to court. It removed that provision of just anybody. And if you look at Section 29(5) of the new act, it says any aspirant who participated in the primaries of his political party who has reasonable ground to believe that any information given by his political party in the affidavit or any document submitted by that candidate in relation to his constitutional requirement to contest the election is false may file a suit at the Federal High Court seeking that the candidate seeking a declaration that the information contained therein in the affidavit is false. So now it is only aspirants that are cloaked with the locus to challenge such information. And so you find out that if you are not an aspirant in the primaries of his political party, you go to court, and then the court says, look, you are a busybody because the law does not cloak you with locus standi. You can have a cause of action, but do you have a right of action? So these are two different things, and that's why a lot of people, the ordinary people, like Rufai, and not you, Rufai, who does not understand the law. It's an aside though. Like the ordinary people will tell you that this is confusing. And so I needed time to clarify. Because in the old law, anybody could go to court. But in this new law, not everybody now has the power to go to court. And then also on the issue of certificates, even the Supreme Court had heard consistently that for you to prove the forgery of a document, you must present the original and then compare it. And in most cases, who to state the forgery of a document? The maker. And so that was why they asked the PDP candidates, it be stated under cross-examination that the principal of the school is still alive. And so the court is wondering, if the principal is alive, why didn't you bother calling him? So these are the issues, and because one thing is to have a strong ground, another thing is to have, the locus, the power to actually present those grounds, at the election petition. So these are the two, issues are very conflicting, and you've consistently seen in most election petition cases that had come up.
How about evidence, the presentation of evidence and the kind of evidence that's admitted? Because as part of the ruling, some of the evidence presented by the petitioners were dismissed by the court. And we saw this also play out, at the presidential election petition courts. Because you've explained local standing, you've explained who has the right to petition, but how about the evidence, and why would evidence be dismissed by the courts, especially as it happened with the Lagos State petition?
Yeah, but before I go there, please quickly permit me also to dwell on the issue of citizenship, because that also came up yesterday.
For the deputy governor.
It's section 28(1) says, subject to other provision of this section, a person shall forfeit forthwith his Nigerian citizenship if not being a citizen of Nigeria by birth, he acquires or retains the citizenship or nationality of a country other than Nigeria, of which is not a citizen by birth. So what that means is that you cannot forfeit your Nigerian citizenship once you're Nigerian by birth. And then now to come to your question, I would give you an example with, let me start an example with the one, because we're always quick to refer to saner societies, quote and unquote.
Why sane society?
Yes, we're in sane society. If, for example, as a policeman, you break into somebody's house in London without a court order and obtain evidence, at the end of the day, that person whose house you broke into to obtain those evidence does not only have the power to sue you, he will claim damages. And so that also applies to law. The way evidence is presented in law matters a lot. For example, election petitions will tell you that document to be tendered at the petition must be filed with the witness deposition, which also must be filed at the presentation of petition. And so, because there are no room for amendment by the rules, there are no room for amendment. And once you have filed, you cannot amend. Even when you are bringing a subpoena witness, the witness are valuable to you. And so one of the witness was also the Labour Party candidate, whose testimony was also discountenanced because he was sued alongside the APC candidate. And the tribunal said, well, this ordinarily ought to have been between you and the man who won, and not between two people who lost the election. And so every testimony and documents tendered by that candidate, the moment that party was expunged from the list as a party, every document submitted by that party is expunged also, all of them. It is presumed that they never participated. And unlike before, the issue of admissibility is usually, debated and argued at, presentation stage. But because now, to fast-track the administration of justice, what we do, you admit all pending your final argument. At the final argument, that is when parties now begin to present argument as to which document they are disputing and which one they would allow. And so the court will review all of those documents, who is tendering them, who is a proper custody. Is it a public document that or are you the maker of such document? If you are not a maker of a document, you can't be tendering the document because you cannot even be cross-examined on such a document. And so that's why you find out that in most cases, some of these documents are expunged. And then you also have a situation where you claim to be a witness, a polling unit agent who came to tender results. But at the end of the day, on examination of those results, it is discovered that the candidate, the party, the agent that signed it is different from you. And so you can't be tendering result of a polling unit where you claim to be an agent, but in actual sense, you were not the agent. So what the court also do is to expunge those documents from the record because the person who tendered them
Okay.
was not even present there, so cannot speak to those documents.
So, I mean, I don't know if you have the Evidence Act here, which I'll have wanted you to be able to make some clarifications because, you know, we had a lot of this. How to tender proper evidence, because it's really important. We've had a lot of discrepancies. That's number one. Number two, I also like to ask you, you know, for a lot of people that watch decisions, we are at sea as regards what is happening. There was a case of, you know, certificate forgery here. There was a subpoena to WAEC. You know, there's been a lot of back and forth. That's why the candidate of the PDP, Jandor, did say, oh, they didn't take all the evidence in and all of that. But also look at the case for Enugu, for instance, where the holders of the documents, the certificate in contention, the NY certificate, they came on this show to say that that certificate was false. And you saw the ruling. So what would you say about cases like that?
Rufai, even I have the Enugu State judgment here. I've been reading through it before. You know, the issue here is if the holder or the maker of a document comes on TV to say that that document that this man is holding is false, but refuse to go go to court to testify, the court cannot rely on his testimony made on air.
Okay.
The court will rely on a testimony made before it. It is not a statement he issued somewhere. The court,
so
because...
what if the person had been sued prior to going to testify? Because, you know, after that assertion was made here, then there was a court process instituted against even the NYSC itself, you know.
So
what if that's an impedance?
The issue here is, first and foremost, because I read that judgment and where the court said the requirement, the court dwells on the requirement for contesting an election. That the requirement for contesting an election is primary school certificate or its equivalent anyway. And that is equivalent also if you go to section 318 or section 319, means if you can read and write in the opinion of INEC. And that's so, if you do not tender a certificate, and then somebody is saying, oh, you do not even have that certificate, or the certificate you have.
The owner of the document, the supplier of the document.
The supplier of the document. If the supplier of the document did not come to court, to cut a long story, if the supplier of the document did not come to court to say that document that you are flashing everywhere is forged or is fake, then there is nothing, the court cannot take evidence from statements that were made, except also there is a court order or there's a court ruling previously, a judgment that specifically declared that document to be forged. And then the court will take judicial notice of that judgment. You can now tender that judgment before the court. But also, I also agree that at this level, at the tribunal level, usually you have conflicting judgment on the same set of facts. This was the same thing that happened at the governorship election petition matters before, was it 2011 or 2015, the Supreme Court in its wisdom now decided that all matters pertaining to governorship election petition shall terminate at the Supreme Court. Before it was at the Court of Appeal.
Yes,
but you...
Liborous, the matter before us is not Enugu.
Okay.
I also read that Enugu judgment. The tribunal said, look, you don't need an NYSC
certificate discharge.
Somewhere in that same ruling, it pointed out that there had been a high court ruling which validated Mbase NYSC certificate. And that's what the court, had before it. But I wanted to ask you, the Lagos State governor says his victory at the tribunal is victory for all. Do you agree that it's actually victory for all?
Because if you had three major political parties, to answer your question directly, I would say victory for the party and victory for those who probably didn't participate because they didn't believe in the entire process. And then, but it cannot be victory, because that's why we say there is nothing like absolute justice. It's like saying it is justice for everybody. Because there are people who are still saying that, no, this can't be so. We are going to test this further on appeal. And then we are going to test it at the Supreme Court. So for them, it can be victory. For the other party in Labour and PDP, but the Labour Party have not spoken. For them, you can't say it is victory for all, because they will still have their grounds. And that's why there are room for appeal. But for his party, for his people, for those who also believe in him, that's victory for them. And also it will enable, focus. Because no matter how strong a politician is, once there are litigation in court, you will consistently look, behind, even though you want to move as fast as you can. And so that is why the court, also the legislatures in their wisdom, also limited the time for dealing with election petition. Unlike before, when you can take the entire 4 years to treat a governorship election petition matter. I remember the Ngige own took almost 4 years, Ekiti 2 years, plus Edo, the same thing. So, but now, worst case, you wait for 180 days and then 60 days, another 60 days, worst case, you're done. So I think, yes, we're developing our electoral jurisprudence at the end of the day, but I don't think there's any new thing that has been said that had not been said previously by the Supreme Court. But the problem, like I always say, the issue here is the presumption of regularity. You cited the Evidence Act, the presumption of regularity in favor of INEC. Once results are announced, INEC has a window of 7 days within which to review. And after that 7 days, it is only the court that can overrule or nullify that election. And so, no matter the irregularities noticed, once results are announced, the law presumes them regular. It is now you who is saying they are not regular. The onus is on you to prove polling unit by polling unit, and not just polling unit by polling unit. Who is the person that is tendering those documents? You can't bring a witness who was a collation officer to tender documents from a polling unit where it wasn't an agent.
Okay.
Those documents will be expunged.
All right, so help us to understand, because I think this is important for us, and thanks for breaking down some key aspects, that have made some people question certain judgments as to, okay, why is this the case? Why is that the case? But breaking down for us, is this matter of pre-election or it's
post-election?
No, with regards to, this is a party issue, this is a pre-election matter in terms of authenticity of the candidate, and also which is part of what the PDP and the Labour Party had contested or petitioned the courts, that the candidature of Governor Sanwo-Olu ought to be questioned in terms of him being flag bearer and Dr. Hamzat. Beyond that was also the question around the lawful votes cast. And I know you talked about INEC. I mean, in this case, INEC was the first responder from Labour Party. But let's talk about how perhaps we can begin to change maybe a modification of the Electoral Act with regards to the responsibility of INEC when it comes to election matters, and then being held responsible. Because if they're saying that the election wasn't well conducted and there were irregularities, hence they felt that the votes were not reflective of the people's will, shouldn't INEC be held culpable?
But in this case, first and foremost, the case of Lagos State, it was not the prayers of the petitioners that the votes were not reflective of the popular wish. What both petitioners were chasing were issues of qualification, that the two of them, there was another issue that the deputy governorship candidate did not pay security for deposits separately from the governor. The security for deposit that was paid for just the governor, and that there was no security for deposit for the deputy governor. And the court heard also that no governorship candidate is qualified to vie for an election except he nominates a deputy governor, a running mate, and that the two tickets are a joint ticket. They are one. They are Siamese twins that cannot be separated. And on that note, you can't, once a deposit, security for deposit is paid, it is presumed, it is authentic because they are one ticket. You don't expect, you are trying to split hairs. That's on one side. Then on the second side was the issue of qualification. Qualification, first and foremost, is the base, the barest minimum, like I had said, is school certificate, and if you can read and write in the opinion of INEC. And if you're questioning the certificate of a candidate, the law also says here that it is a party, section 29(5) says somebody who contested in the primaries, who participated in the primaries, unlike the previous section 35 that says just anybody. So are you a member of the party? Did you participate in the primaries? Just like in Peter Obi's case where the APC questioned his candidature not being a member of the party. And the Court of Appeal said, no, you are not a member of their party. So you cannot be talking about who is a member or who is not a member. The membership of a party is left to the party and not to a meddlesome interloper. That said, the candidature and they talked about the issue of dual citizenship, and Section 28 clears that you cannot renounce your Nigerian citizenship.
No, well, they did challenge, I mean, we're out of time, but they did challenge lawful votes. They said that
the issue
not
of
duly elected by majority
the issue of lawful votes, where the problem usually is if the margin of lead is so wide, it becomes very difficult for you to prove unlawful vote. Because if, for example, like in the case of Enugu, that Rufai cited, where even votes are deducted, you still find that the margin of lead is wide. But like the Supreme Court said, in Oyetola's case, if you are challenging lawful vote, that you must also be able to present beavers to show that they were overvoting. And that was how...
out of time now.
Okay. Well, I really wanted to talk about two cases. And I wanted to prove to you that there's been a lot of discrepancy as regards this election petition tribunal, where you made the point as regards this meddlesome interloper. For instance, in the case in Delta that involved Elumelu, the reason why the man was pulled out was because the tribunal ruled that the Labour Party did not duly sponsor the...
That was before the Rufai, that was before the Court of Appeal judgment. The moment the Court of Appeal gave that judgment, quickly, let me say this for the...
And I also want to talk about Kanu, but we have to see.
No, quickly.
We have to see. Ayo, the floor to you. We have to listen to Ayo.
No, seriously, because
we have to go.
We'll probably have to bring you back.
I need to clarify this.
All right, Land.
The issue of Elumelu was before the Court of Appeal judgment. The moment the Court of Appeal made that judgment in the Presidential Election Tribunal, the subsequent judgment of the Court of Appeal said Elumelu cannot question the membership candidate of the Labour candidate that won. And so that was why the Labour candidate was returned as the winner of that election. So that ground has been cleared by the Court of Appeal.
Okay, we'll talk Kano sometime
Thank you very much, Mr. Liborous Oshoma, for your time this morning and for breaking down some technical legal terms and just helping us to understand better. Thank you.
My pleasure.